exactly at 3:17 p.m. Eastern Time today, January 19th, 2026, a federal judge did something that had never happened in the 249-year history of the United States. Judge Tanya Chutkan formally referred the criminal conduct of a former president directly to Congress and demanded immediate impeachment proceedings. Let me say that again so it's fully understood. A sitting federal judge looked at the evidence in front of her, 14 documented violations of court orders, witness intimidation, obstruction of justice, and concluded that Congress could not wait any longer. This is not speculation. This is not anonymous sources. This is a 47-page legal document filed in federal court, available to the public right now, and in approximately 72 hours, the House of Representatives will vote on whether Donald Trump becomes the first president in U.S. history to be impeached 3 times. I've been covering this story for months. I warned you this was coming. I told you judges would eventually stop tolerating the obstruction, that the machinery of accountability would begin to move. Today, it moved. Let me walk you through exactly what happened, what it means, and what comes next. So, let's establish exactly what took place today, because the details matter. Judge Tanya Chutkan presides over one of the federal criminal cases against Donald Trump. For months, she has been dealing with something no federal judge has faced at this scale: a defendant who simply refuses to follow court orders, gag orders violated, witnesses contacted despite explicit bans, social media attacks on prosecutors, judges, and potential jurors. Not once, not twice, but 14 documented times in just 3 months. Each time, the court issued warnings, contempt citations, fines, and each time the behavior continued. Today, Judge Chutkan stopped asking. She filed what is called a formal criminal referral. Think of it as a judge officially telling Congress, "I've exhausted my options. This defendant is so dangerous to the administration of justice that you need to act now." The language in the referral is worth reading directly. Quote, "The defendant's repeated violations constitute a clear and present danger to the administration of justice and demand immediate intervention by Congress." Clear and present danger. That is not judicial rhetoric. That is a legal conclusion with enormous weight. And she didn't just send a summary, she sent the entire evidentiary record. 14 violations of the gag order, each one time-stamped, screen captured, and archived. Transcripts of 7 separate contempt hearings where Trump was directly warned. Phone records showing coordination with co-defendants despite court-ordered no-contact restrictions. Social media posts targeting prosecutors, judges, and members of the jury pool. Internal communications from Trump's own legal team acknowledging the violations. Sworn statements from former federal judges describing the conduct as unprecedented. And then the most damaging piece of all, recorded conversations. Audio of Trump discussing plans to defy court orders with close advisors. Evidence that not only shows behavior, but establishes intent. This is the kind of evidence that ends careers, that ends administrations, that ends political movements. And all of it was delivered to Congress in a single 47-page document. Now, here's what makes this historically significant. This has never happened before. Not during Watergate, when Nixon was fighting subpoenas. Not during Clinton's impeachment, when obstruction was alleged. Not during the Saturday Night Massacre, when Nixon fired special prosecutors. Never has a sitting federal judge formally initiated impeachment proceedings against a president or former president. Judge Chutkan crossed a line no judge has ever crossed because she concluded the conduct left her no other choice. And Congress was not caught off guard. To understand why Judge Chutkan took this extraordinary step, you need to understand how federal courts actually work. Judges have limited tools. When a defendant violates a court order, the judge can issue warnings, impose fines, hold them in contempt, or in extreme cases, revoke bail. But what happens when none of that works? What happens when a defendant is rich enough that fines don't matter, powerful enough that jail seems politically impossible, and defiant enough that warnings are ignored? That is the trap Judge Chutkan has been in for months. Each violation raised the stakes. Each contempt citation that didn't change the behavior made the court appear weaker. And Trump, whether by instinct or strategy, kept pushing. He attacked prosecutors by name, posted about witnesses in active criminal cases, shared information that could influence jury pools, coordinated with co-defendants. He was legally barred from contacting. And when warned, he did it again and again and again. This is what systematic obstruction looks like. Not one bad decision, not one angry post, but a deliberate, repeated, documented pattern. And here is the critical point most people miss. A judge's authority depends on enforcement. If orders can be violated without consequence, they become meaningless. If a defendant can ignore the court repeatedly, the entire system is weakened. Judge Chutkan understood that her continued tolerance was damaging the judiciary itself. Every unpunished violation sent a message, not just to Trump, but to every defendant in every federal courtroom. Follow the rules or don't, it doesn't matter. That is why she escalated. The criminal referral is not about politics, it is about institutional survival. It is a federal judge saying, I cannot fix this alone. The conduct is too dangerous. Congress has power, I do not. Use it. This matters because it changes the framework completely. Trump's defense has always been that this is political persecution, partisan prosecutors, Obama-appointed judges, deep state conspiracies. But that defense collapses when the person making the allegation is a life-tenured federal judge acting on sworn, documented evidence. Judge Chutkan did not leak to reporters. She did not give interviews. She filed a formal legal document in open court, attached the evidence, and transmitted it through official channels. That is not persecution. That is procedure. And now Congress has to respond. Within hours of Judge Chutkan's referral, Congress moved faster than anyone expected. The articles of impeachment had actually been drafted months ago, sitting quietly in committee since November 2025. 8 specific charges: obstruction of justice, witness tampering, contempt of court, violation of court orders, abuse of power, conduct unbecoming a public official, threat to the constitutional order, and incitement. Until today, those articles had about 87 co-sponsors, all Democrats, not enough to pass. As of tonight, that number has exploded to 231. That is a majority of the House of Representatives. That is enough votes for immediate impeachment. And here's what's remarkable. The new names are not progressive Democrats from safe districts. They are moderate Republicans from swing districts who had defended Trump through 2 previous impeachments. Representative Mike Lawler of New York held a press conference this morning, a Republican from a district Biden won. Listen to what he said, quote, I swore an oath to the Constitution, not to any individual. When a federal judge says a former president is obstructing justice, I have a duty to take that seriously. Representative Don Bacon of Nebraska, another Republican, another defection. The political calculus has changed overnight, and Democratic leadership is not waiting. They have invoked something called Rule 99, Section 2, a fast-track procedure that requires a full floor vote within 72 hours. That motion was filed this morning, which means that by Monday, January 13th at the latest, the House of Representatives will vote on whether to impeach Donald Trump for a 3rd time. 72 hours. That is the window. With 231 co-sponsors already committed, the math is relentless. Impeachment is no longer a question of whether it will happen. It is a question of margin. Will it be narrow, 218-217, or will it become a blowout as more Republicans break ranks over the weekend? Because that list is growing hour by hour. Moderate Republicans who were waiting for political cover are now jumping ship. They see a criminal referral from a federal judge. They see documented evidence of obstruction. They hear from constituents exhausted by constant chaos and understand they cannot go on national television defending witness tampering after a respected judge has signed her name to a 47-page referral. The political ground has shifted beneath the Republican Party, and Trump's response has made everything worse. Since yesterday afternoon, he has been posting nonstop on Truth Social, all caps rants about rigged courts, attacks on so-called Obama judges, claims of political persecution, conspiracy theories. But then came a post that immediately set off alarms throughout Washington. Quote, "If Congress moves forward with this witch hunt, patriots must converge on Washington. The Second Amendment exists for moments like this." Read that again. A former president openly calling for armed resistance to Congress. That is not campaign rhetoric. That is not political posturing. Law enforcement is treating it as a threat. Every post he makes now becomes evidence. Every escalation strengthens the case against him. He is making the prosecution's argument for them in real time, and Washington has responded accordingly. National Guard units are deployed across the Capitol complex. Steel barricades are going up around federal buildings. Pro-Trump protesters are gathering near the National Mall. Counter-protesters demanding accountability are gathering near the Supreme Court. Law enforcement is stretched. This is what the Capitol looks like right now. Not because of an election, not because of a foreign threat, but because a former president faces impeachment and has called for armed resistance. Most current coverage is focused on the impeachment vote. Will it pass? How many Republicans will defect? What will happen in the Senate? Those are important questions, but they are not the most important. Here's what most people are missing. Judge Chutkan's referral did not go only to Congress. The evidence of witness tampering, obstruction of justice, and criminal contempt has also been sent to the Department of Justice. That means this is no longer just a political process. It is a parallel criminal investigation. If federal prosecutors establish that Trump directly coordinated with witnesses to influence their testimony, that is solicitation of perjury, a serious federal crime. Witness tampering carries significant prison exposure. So does obstruction of justice. Multiple federal grand juries are already active in Washington, D.C., Miami, and Atlanta. It is entirely plausible that new criminal indictments could arrive while impeachment proceedings in the Senate are still underway. Think about that. We could be watching a Senate trial while a federal grand jury is simultaneously handing down new charges. This is constitutional territory the founders anticipated but hoped we would never enter. Multiple mechanisms of accountability operating at once. Impeachment in the House, trial in the Senate, federal criminal prosecution in the courts. And then there is something else that is barely being discussed publicly. Reports indicate that quiet conversations about the 25th Amendment have already begun. The 25th Amendment allows removal from office without impeachment if a president is deemed unable to discharge the duties of the office. It requires the vice president and a majority of the cabinet. It can move quickly, overnight, if necessary. The fact that this option is even being discussed tells you how serious officials believe this situation has become. Now, let me be clear. I am not predicting that the 25th Amendment will be invoked. I am telling you it is being discussed, and that discussion itself is historically significant. Meanwhile, the Republican Party is fracturing in real time. You have loyalists like Representatives Marjorie Taylor Greene and Matt Gaetz doubling down, calling for protests, defending Trump without reservation, attacking any Republican who breaks ranks. And you have pragmatists like Lawler and Bacon peeling away, citing their oaths to the Constitution. Internal threats are rising. Lawmakers who defected are facing harassment from Trump's base. The party itself is tearing apart. With the 2026 midterms just 10 months away, many Republicans see electoral catastrophe ahead. If they remain tied to this level of chaos, they are calculating, hedging, crafting exit strategies. That is the deeper layer here. This is not just about an impeachment vote. It is about the collapse of a political coalition that has dominated Republican politics for nearly a decade. Once members defect publicly, the dam does not reseal, it breaks. Each new defection makes the next one easier. And internationally, the consequences are already visible. A former US president threatening armed resistance while facing impeachment is not a normal headline. Our allies are alarmed. Our adversaries are watching closely, assessing instability, looking for weakness. Domestic turmoil always carries global consequences, and right now, to the rest of the world, the United States looks deeply unstable. Let's talk about what this means for ordinary people, not politicians, not lawyers, regular Americans trying to understand what is happening to their country. First, the economy. Markets hate uncertainty, and there is nothing more uncertain than a constitutional crisis unfolding in real time. Futures markets are already reacting. International investors are watching. When the world's largest economy looks politically unstable, money moves, interest rates can shift, supply chains can adjust, hiring decisions get delayed. None of this is guaranteed, but all of it becomes more likely when the political system is consumed by crisis. Second, trust. This is harder to measure, but maybe more important. How do you explain to your children what is happening right now? A former president calling for armed resistance, National Guard troops surrounding the Capitol, a federal judge concluding that obstruction of justice has become so severe that Congress must act immediately. This damage is hard to rebuild. Faith in institutions, the belief that the system works, trust that disagreements can be resolved through process rather than force. Every generation of Americans has to decide whether the Constitution is just words on paper or something that truly limits power. This is one of those moments. Third, safety. Law enforcement is not deploying the National Guard as a mere precaution. They are deploying because they believe the threat is real. The memory of January 6th is not abstract, it is operational. Agencies know exactly what happens when rhetoric turns into action. They watched a mob attack the Capitol in real time. They are determined not to be caught off guard again. For people in Washington right now, federal employees, Hill staff, families living near government buildings, the next 72 hours will be tense. Security checkpoints, street closures, helicopter noise at night. That is the human reality of a constitutional crisis. It is not just cable news drama. It is people canceling plans, keeping kids home from school, wondering if their commute will be safe. And fourth, the future. Whatever happens on Monday, the political landscape has permanently changed. If Trump is impeached for a third time, he becomes a historical figure unlike any other, defined not by political achievements, but by repeated accountability proceedings. If he is somehow acquitted in the Senate, he remains politically viable but legally exposed, with federal criminal cases continuing regardless of congressional votes. Either way, the coming years will be consumed by trials, appeals, investigations, and ongoing instability. There is no path back to normal from here, only forward through whatever comes next. So what are the possible scenarios from this point? Let me lay out what the next few weeks could look like, not as predictions, but as genuine possibilities based on what we know right now. Scenario 1, impeachment passes. The Senate convicts. This requires all Democrats plus at least 18 Republicans in the Senate. That is a high bar, but it is not impossible, especially if more evidence emerges during a Senate trial, or if Trump continues to escalate his rhetoric in ways that make him impossible to defend. If conviction occurs, Trump would be permanently barred from holding federal office again. His political career would end in a constitutional, legal sense. Scenario 2, impeachment passes. The Senate acquits. This is perhaps the most likely outcome based on historical patterns. The House impeaches, the Senate holds a trial, but 67 votes for conviction never materialize. In this scenario, Trump survives legally, but is severely weakened politically. The evidence presented during the trial becomes part of the permanent public record. Republican senators who voted to acquit carry that vote into every future campaign. Scenario 3. The 25th Amendment is invoked. This would be faster than a Senate trial, potentially overnight. It requires Vice President B and a majority of the cabinet to conclude that Trump is unfit. It is being discussed. Whether it actually happens depends on factors we cannot see from the outside. But the mere fact that it is on the table shows how unstable the situation is perceived to be. Scenario 4, additional criminal indictments. Regardless of Congress, federal prosecutors continue their work. New charges could arrive at any time: witness tampering, obstruction, criminal contempt. This would create the unprecedented situation of a former president facing active criminal prosecution while simultaneously undergoing impeachment proceedings in Congress. None of these scenarios are mutually exclusive. Several could happen at once, and that is perhaps the most important point. Trump does not face one threat. He faces multiple threats converging at the same time: congressional, judicial, criminal, and political. The next 72 hours will determine which of these paths becomes reality. Before I close, let me give you the 3 things you need to remember from everything we've covered. 1. A federal judge has formally referred criminal conduct to Congress for the first time in U.S. history. This is not politics. This is a life-tenured judge acting on documented evidence of obstruction and witness tampering. 2. The House will vote on impeachment by Monday. With 231 co-sponsors already committed, passage is virtually certain. The question is the margin, and whether more Republicans break ranks over the weekend. 3. This is bigger than impeachment. Criminal investigations continue. The 25th Amendment is being discussed. The Republican Party is fracturing, and the next 72 hours will shape presidential accountability for generations. I'll be covering this story as it unfolds. If this breakdown helped you understand what is really happening beyond the headlines and cable news panic, consider subscribing. I try to do what I've done today: take complicated situations, explain them clearly, and help you think about what comes next. Leave a comment below. Tell me what you think Congress should do. Tell me what you think will happen on Monday. This is one of those moments when being informed truly matters. See you in the next one.